Welcome and good afternoon. This is the Victorian Medtech Skills and Devices Hub Medtech series. My name is Anita Petrus and I'll be your MC for today. Thank you for joining us with this session, which I think will be really informative and really helpful, particularly for you who are in that sort of early phase of your commercialisation journey. So today's session is from IP to investment, what investors look for in a patent portfolio. So before we get started, I'd like to do an acknowledgement of country. So I'd like to acknowledge the traditional owners of the land from which I am hosting this webinar, the Wurundjeri people of the Kulin Nation, and I pay my respects to those elders past and present. So today's webinar focuses on intellectual property, a key component in your commercialisation strategy. And a well-structured IP portfolio not only protects your innovation, but it also plays a key role in attracting investment, partnership opportunities, and plays a key part in gaining market share for once your product is on market. We're pleased to have Robbie Bookeram with us today to share his expertise on how to build and manage an effective IP portfolio. From early stage strategy, where most of you will be, to attracting seed investment through to the latter stages of your commercialisation journey where you may be looking to scale or license or even be acquired. So today's session will run for about an hour with about approximately 20-25 minute presentation followed by a 25-minute Q&A session. For those that have submitted questions prior to the webinar today, thank you. We'll endeavour to get through some of those, but feel free, if you think of questions along the way, to pop them in the chat function in the webinar as well, so I can look at those and see if I can raise them and if we've got time to do so. But if we don't get to all of your questions today, Robbie has kindly offered to answer those via email where appropriate and relevant, and we haven't covered those today. So yeah, that's good for you. So keep those questions coming in. So it's my pleasure to introduce Robbie Bookeram. Robbie is an Associate Principal and Trans-Tasman Registered Patent Attorney at FPA. He specialises in medical technologies, complex mechanical inventions, and registered designs. He advises startups, researchers, and established medtech companies on building a commercially robust patent portfolio with particular expertise in medical devices and engineering-led healthcare technologies. With his mechanical engineering background and deep patent prosecution and strategic experience across Australia, the US, Europe, and Asia, we're in safe hands today when considering IP and commercialisation strategies for medical technologies. So welcome, Robbie. Thank you for joining us today, and I'll hand over to you.
Cool. Thanks, Anita. And thanks everyone for joining. So step one is trying to make sure I get the share screen going well. So just let me know if that all looks pretty good. I want to take it that it is working fine. All right, so I think this presentation is going to have a patent slant to it. Although when we're talking IP, we're obviously, IP is far more broad ranging than just patents. And as I'll sort of touch on in the presentation, depending on your technology, it may not only be patents that are relevant to you, and in some cases, patents might actually be not that relevant at all. But what I'm going to talk you through is probably the patent leaning side of what investors look for. But you should be able to hopefully sort of bridge some gaps as I sort of go through this around where your technology might lie and how that may play into other forms of IP that your company is going to invariably have. You're generally not going to just have patents. So I'll kick off with just some patent fundamentals, bearing in mind that there might be some people in the audience who are probably not super familiar with patents. So I'm going to touch on very briefly some basic fundamentals that will hopefully then help build into some of the sort of more complex topics that we'll be touching on. And it's probably also worth bearing in mind that a lot of these topics could be presentations in their own right. So there is going to be an element of sort of touching on a lot of these things and then hopefully expanding on them, maybe in the Q&A. So patent claims are going to be touched on. They're effectively the really important part of a patent, and I'll talk you through what they are and why they're important. We're going to talk to investor expectation of IP in medtech, although in truth, this is really sort of almost tech agnostic to some degree. And then we're going to talk about due diligences. So I'll be trying to go through these fundamentals pretty quickly. At its core, a patent or a patent application is a key asset for facilitating commercialization, investment, and capturing value. Patents are effectively monopolies that are granted in exchange for teaching the world your invention. So right away, what should be triggering in some people's minds is, to get a patent, I do need to tell people what I'm doing. And depending on the exact technical area you're in, maybe that might not be what you want commercially speaking. And basic rule of thumb is, if it's reverse engineerable, then it's probably patents are something you're going to have to think about. If it's not, then there might be other sort of avenues of protection that you might want to be looking into. Patents give you rights to exclude others from doing what you've patented and what you've covered, and I'll sort of talk about what that means a bit later. But one of the things that early stage startups or people not too familiar with what patents do and don't do, they often get tripped up by this concept of you've got the right to exclude others from doing what you've patented, but it doesn't necessarily give you a right to do the thing that you've patented. And what this is meant to illustrate is this sort of delineation between patentability. So have I done something that is worthy of getting a patent? And what we sort of call freedom to operate, which is, can I freely do the thing I want to do without potentially stepping on anyone else's IP rights? So we'll touch a bit more about that later. Patents as an asset can be sold, licensed, and exchanged. So that's effectively where the value in the patent comes in. And patents typically will have a 20-year term. And in some cases, in pharmaceutical patents, it could be a bit longer. So what can I patent? You can patent devices, manufacturing processes, chemical compounds. I've got software there with a question mark. And for the purposes of this presentation, don't just treat software as being pure software. We're talking things like computer implemented inventions. We're talking applied AI. There's a question mark there because there is an element of gray when it comes to software and exactly what it is that you've come up with and exactly how you go about protecting it. And in some cases, the patent system is well built for it, and in other cases, it might be patent ineligible, in which case there might be other IP avenues for you. I've also got a question mark around things like methods of medical treatment and methods of diagnosis. And the real question marks there really just come from the fact that in certain jurisdictions, you might not be able to cover these things. In the case of methods of medical treatment, you could probably half guess why. The infringer of a method of medical treatment is often going to be the doctor or clinician, and there are generally carve-outs in some laws to prevent you effectively from covering that sort of invention, although that's not the case in all jurisdictions. And then there's the things that are just generally well taken across the globe as not being patentable, and that's things like just the mere ideas or schemes, business methods, mathematical algorithms. And the point on mathematical algorithms is I'm talking the math here, not necessarily if you've got an algorithm that operates in a system that performs, executes something technical, that is potentially patentable, but purely protecting the math per se is not. So given there's a lot of people who have seemed to be quite interested with the with sort of AI, computer implemented invention software that are going to be present in the audience, I have dedicated a slide to sort of give you what I would say is guidance on patent eligibility for inventions that sort of fall within that sort of broad spectrum. I'll also make absolute note that just because something might not be patent eligible doesn't mean it's not clever or it might not be of absolute commercial value. It's really about whether or not you can actually put a patent around it. And whilst I'm not going to talk to every sort of example I've got in the boxes there, I'll talk to a few just to sort of hopefully illustrate to some degree where that line is between patent eligibility and ineligibility is for computer implemented inventions. So if you're talking things like software that merely collects, processes, or displays information, so in effect, you could sort of view it as computers doing computer things, then you're probably going to be on that unlikely to be patentable side of things. Similar for computer implemented, business methods, e.g. workflow automation systems. And then as you sort of go across that spectrum towards doing something a little bit more clever on, let's say, so if you picture computer inventions generally, or even applied AI, as you've got the black box in the middle, you've got potentially inputs at one end, outputs at the other. If it's just you're putting an input in, goes into black box, there's some very basic output that gets spat out, that's generally going to be in a non-patentable or very difficult to patent side of things. Whereas if you're doing something clever at either end, so if there's something particularly clever you're potentially doing with the pre-processing or the post-processing of the information, or you're actually taking the output and doing something technical with it, then you start to go away from just being software or computer doing basic things to actually solving a technical problem. And once you start to solve technical problems, then you're starting to go into realms of you're likely going to be on the green side of patentability. There is a lot of this that's going to sort of be partly dependent on how the patent is sort of framed and how the invention's framed around exactly what's going on and where the clever bit is. But I guess the whole, purpose of this slide is to make clear that just because you have technology involved, be it computers, AI, etc., it doesn't necessarily mean it's going to be patent eligible. It really comes down to what is really going on, what the invention's really doing, where the clever bit is, and depending on where that sits, there might be an ability to cover by way of a patent that. And if not by patents, then, as I said, there are other ways that you might look at sort of protecting those sorts of inventions, which I'll sort of touch on a bit later. So with some of the patent fundamentals hopefully out of the way, we're now going to talk to patent claims. And patent claims are really the bit of the patent that are the most important part. They're carefully drafted legal statements that actually define what the scope of protection that you're after is. So the way to sort of think about that is to sort of go, you often hear people say, I've patented my device, I've patented my process, or I've got a patent pending on this stuff. The thing that should probably arise in your mind is, what's that actually even mean? Like, what have you actually protected, or what are you actually seeking to protect? If I told you that there's a patent on this iPhone over here, you sort of have to ask yourself, well, what's actually protected? If I was to remove, if I was a competitor and I released the same thing and I removed the camera, would the patent cover me or not cover me? What's really going on? And for the sake of illustration here, I've tried to use a really basic example of a conventional chair, which we all know about. And I've tried to put a sort of a sample patent claim to it to sort of illustrate the point of what a claim is and what it does. So let's say there is a patent on this chair, and that is the claim for it. So it's a chair that comprises a seat, and it has at least 4 legs secured to the seat, such that in use, the seat is substantially horizontal. So that definition maps pretty well to that chair. But if you sort of put a bit of thought into it, you start asking yourself, so what's it mean then if someone comes along and does effectively the same thing but puts only 3 legs on it? Will the patent cover that person? Answer would be no. The claim says it's at least 4 legs. So if someone comes along and does the same thing but with 3 legs, then they've avoided the patent. If, for example, someone comes along and does the same chair but, say, removes the backrest, so picture a 4-legged stool, does that claim still cover a 4-legged stool? It's still a chair, still got a seat, still got at least 4 legs. you'd say yes, it would cover that circumstance. So hopefully by way of this very basic example, you sort of get an idea of why claims are important and why when investors are actually going to be looking at your patents, what they're really caring about is what do the claims say, what do they cover, and is what they're covering commercially useful. So hopefully a bit of patent talk now put to one side, we can start sort of looking at the investor side of the equation and what they're actually looking for. And the reality is that it depends on what stage you are as to exactly what investors are looking for at a given point in time, and it does evolve. So I'll talk to just some of these early stage examples here, but you could effectively sort of extrapolate on from there as to what investors will look for as things progress. So at a pre-seed level, or early stage, what they're really looking for is, can you demonstrate a good understanding of the IP and competitive landscape? So what I mean there is both having a fundamental understanding of IP, what IP is involved in your tech, but also understanding what is out there by way of competitors in the space. Now, that doesn't mean full-blown patent searching for freedom to operate purposes by any stretch of the imagination at that early stage, because investors know that that's expensive. But what we're really talking about here is what are sort of the key players in this particular area you're planning to play in? What are they doing? What sort of IP do they have? What are they protecting exactly? And then maybe having some level of understanding of where you sit relative to that, whether that means having done some preliminary sort of infringement analysis to work out where you sit, or having done some analysis as to where your potential new innovation lies in the sense of how novel or inventive it might be. They want to see a defined IP approach aligned with your business model. So this sort of goes back to almost sort of more holistic lens here of putting a business model together and making sure that the IP tracks with that business model. And depending on, again, your technology, what they probably want to see is either ideas around, if you haven't already sort of done things like filed patents, it might be around what you're planning to do. So do you have patent applications that you're thinking about filing? What are they going to cover? Is there any trade secrets that you're going to have? So things that you probably aren't going to have out in the ether that would be the case in a patent document. Depending on your technology, if you're sort of more like in the software as a service space, where maybe patents is going to be either unimportant or certainly not the primary way you might go about it, then what's the plans around how you're going to sort of protect that? Do you have plans for contractual controls? And that's normally how that type of invention might be covered. It's by way of sort of effectively limiting access through contracts. And then there's obviously things like branding, such as trademarks, and whether there's other peripheral bits of IP like design protection that might be available to you. And then what they're really looking for is just generally speaking that you've got some basic IP hygiene. And that's sort of around things like IP capture internally. So as your innovation develops over time, are you continuing to monitor, record that information, assess it to work out what you're going to do with it on the IP front, whether it's a case of going, do I need to file a patent around this? I've gone from my initial prototype, I've made an advancement on it. Is that advancement something that I want to look at protecting by way of filing further patents around it? Is it something that's already maybe covered by my initial patent and doesn't warrant an additional filing? It's sort of just being sort of IP aware and knowing what you're looking for. But also, particularly sort of one of the big trip ups with people in academia, so researchers, etc., where there's this big push to effectively publish, put information out there. As some of you may be aware, putting information out there before you've potentially filed your patent application could jeopardize your ability to validly patent later. So having controls in place to make sure that things that might be protectable are assessed at first instance, and an active call is made as to whether you are or are not going to patent before you start putting information out there, because The most common thing you often see, and it happens a lot from out of academia, is situations where people publish journal articles with some really inventive stuff in there, and then they go, well, can I now come back and patent it? In some cases, depending on timing, the answer might be yes. It might be jurisdiction specific, so certain jurisdictions might not allow you to validly protect there if you've previously disclosed. So basically, you want to avoid doing things that shoot you in the foot effectively. And then as you sort of go from pre-seed to sort of later stages, then things start to sort of ramp up around, okay, what protections do you actually have in place? There's going to be a lot more of an eagle eye around exactly what your claims say and what sort of coverage you have on the patent side, as well as starting to look at things like the risk profile as you start to potentially go towards potential market entry. And that's where maybe stuff like doing something that is a bit more heavy on the freedom to operate side might be more necessary than it maybe was early days to start to look at things like de-risking the technology before you release it into the market. So I won't touch on the other specifics there, but you can sort of see how they were all effectively extrapolations from some of that early stage stuff. And it sort of makes sense because the more dollars that are at stake, the more de-risking an investor really wants. So then you get to, I guess, due diligences. And we tend to like to think of these from sort of the two lenses, so offensive and defensive. Offensive is generally what you might think of as a due diligence, the classic performed by an investor side of things. But we also like to think of defensive due diligence as well, which effectively talks to the ongoing self-assessment of what's going on with your IP. So on the offensive side, naturally investors want to understand the value in the company's IP, and they want to try to identify any red flags that would preclude investing. And what is generally important to sort of bear in mind here is that normally from an investor's perspective, the IP piece is almost a box ticking exercise. Generally, there's a lot of stuff that you need to have ticked off on in their minds to get to the point where they then look at the IP. The IP is normally one of the last things they probably look at, really, and what they're generally looking for is just to make sure that it's generally good order. And as I said, they want to be made aware at that point if there's anything in there that's going to potentially throw them off from investing. And I'd probably say to try to distill the various considerations that an investor might have towards the IP, if you were to distill it into these three key considerations, I think this probably covers, generally speaking, any party along sort of the spectrum of whether you're early stage or later stage. And as you'll imagine, the weighting of these is going to be slightly different depending on where you are in your journey. But one of the key considerations is coverage. And as we've spoken about before, if we're talking about analyzing what a granted patent covers or having an informed prediction of what a pending patent application may end up covering, they're effectively talking about the claims. What do the claims actually cover? How broad are they? Are they commercially useful in scope? Do they actually cover what we're doing? Which I'll sort of touch on again a bit later, which is something that might sound a bit obvious, but that can go wrong. And then we're also talking geographical coverage. So have you actually got protection in place in the actual commercially important jurisdictions? So needless to say, if you haven't got filings or proposed filings in the US, then you're probably doing yourself quite the disservice, because in a lot of cases, the US is the big market, and that's where you probably definitely need to have coverage. But with geographical coverage, there's a lot of considerations that go into what countries you ultimately select in, because it is worth bearing in mind that if you're not already aware that patents are jurisdictional, so it's not like you file a patent and you get this worldwide patent that covers everywhere. You do have to select which jurisdictions you want to seek protection in, and needless to say, the more jurisdictions you select, the more expensive it gets. And even the biggest companies in the world don't file everywhere. So there is going to be some strategy and hopefully alignment with your business plan about exactly where you choose to file. Another consideration is the sort of the freedom to operate competitor landscaping piece, which we've sort of discussed a bit before. So again, it might not be anywhere near full-blown freedom to operate by any stretch in the early stages, but it's more about just what are competitors doing, what are they filing. And again, given the sort of jurisdictional aspect of this, oftentimes it's the focus of an investor is probably going to at least at first turn to the US position. So where do you sit relative to the US? So are there any US patents that you should be worrying about? And then there's the unambiguous chain of title / ownership piece. So this is really all about, do you actually own the IP? An investor is going to look at it and go, is there going to be any impediments if I invest in this company around their actual ability, the company's ability to actually use the IP? And so that sort of has sort of two sides to it. There's sort of the inventor side, which is, does the company have the rights from the inventors to the IP? But you also have sort of the other side that sometimes pops up a lot, and again, particularly at academia, is where situations where maybe the university owns the IP, at least at first instance, and then whether there's going to be any sort of potential problems in getting, if you're a startup, spin out of the university, what sort of access do you have to the IP? Are there going to be any restrictions that that maybe the university place that make it, from an investor perspective, a little bit more complicated about their knowledge around how free you are going to be to use the IP? What is the implications there? And a lot of universities, in truth, are getting or have got pretty good systems in place around IP transfer and how that might play out. So it's not always a complete and utter bottleneck, but it can be something that does need to be sorted out at some stage, and investors will definitely be looking at that. And then also you get other situations where IP might be co-owned. So it might be, for example, your company owns the IP with somebody else, say a research institute, could be the uni again. And in those circumstances, again, from an investor perspective, does introduce a layer of complication. Oftentimes we sort of say if there's two owners of something, there's no owners of the thing, because oftentimes a lot of ownership decisions around IP requires both parties to consent. So, in an ideal world, having co-owners is not ideal, but it's definitely something that often does pop up, and how that's managed and being able to explain to investors how that's going to all be managed is really important for them to be able to sort of derive some comfort around this point. And this is sort of a bit of a snippet from a press release of a coverage gone wrong situation. And I'm not going to bore you by reading this entire thing. There is a bit there that's highlighted, but long story short, company has a whiz-bang drug. They've listed it in their prospectus. They talk about the idea of having, they've got their patents that protect this product. But after an actual review of the patents, it was actually discovered that in actual fact, the product in question wasn't covered by the patents. So the patents did have coverage of something, but it wasn't the whiz-bang drug that was covered. And you might sort of go, well, how can that happen? And I won't pretend that I actually know the circumstances behind this, but one of the things to bear in mind, and it sort of walks us nicely into the idea of sort of defensive due diligence, which is really just the ongoing self-assessment piece. As you can probably imagine, the day you sort of develop your, say, initial prototype and you maybe file your initial patent application, there's going to be a lot of product development that goes on between that initial patent filing and you getting towards something that resembles your sort of commercial embodiment that actually hits the market. And over that time, you're probably pivoting on certain things, aspects of the invention might change, but your patent application is obviously progressing on how it was effectively initially drafted. For those who aren't aware, from sort of initial patent filing to sort of patent grant, it's probably sort of anywhere from sort of 4 to 6 years usually. So there's quite a long time between that initial filing, what ultimately gets granted, and in the background there's all this product development going on. So it's conceivable that if things aren't being looked at correctly, that the patent claims might go one way, whilst the actual developed product might go another way, and you end up in this situation where somehow your patent doesn't end up actually covering what you're actually doing. And in those circumstances, you can run into a bit of trouble if you're not doing this continual self-assessment of asking yourself, is the IP actually covering what I'm doing? And to some extent, that is as much driven by at your end as anything, because as a patent attorney, we're probably not going to be completely across everything that you're doing commercially. Look, we'd love to be, and we often push towards being across development so that we can sort of advise you on whether those new developments, for example, warrant further filings, or whether there is anything that we should be doing with the claims as the patent application is going through its process. But sometimes we are left in the dark in that setting, and sometimes there is a bit of a mentality that I filed my patent, I've ticked that box, and sometimes it does become a bit of a disconnect if you're not careful around, again, what the IP is doing and what you're actually doing at the product development level. So a really, really key take home, IP is not set and forget. So constantly sort of reviewing your IP is really important. It's a great, so we're talking about defensive due diligence. It's great to do internal self-assessment for these things, because you want to ideally be investor ready as you're progressing. And to be investor ready, at least from the IP side of things, is making sure that the IP is going in a harmonious direction with how product development is going, because a disconnect there can in many cases render the IP pretty ineffective. And my final slide is just touching upon the other forms of IP that are out there that effectively form part of your overall IP portfolio that investors will be looking at. In many cases, all of these may apply to some level depending on your technology. So you might have, for example, patents to things like the devices. You might have trade secrets and know-how around your software or manufacturing processes. There is inherent copyright in the actual source code. You're probably going to have contracts in place. I mean, NDAs, as we were talking about before, around sort of disclosure control. Having NDAs in place is the thing that maybe allows you to talk about your IP in a setting that doesn't, if you haven't already filed, shoot you in the foot. And I mean, when we're talking about sort of some of the great AI inventions that are coming out these days, a lot of the times the real key bit isn't the AI per se, it's the training data. And in those circumstances, you can't protect training data by patents, but that training data is, in a lot of ways, what makes your AI potentially superior to your competitors. And so having the right security around your training data is also incredibly important. And in some cases, that might be the key bit of IP for your technology. And then you've got things like branding as well, which all play a role. So that's it on the presentation front. Feel free to contact me if you've got any questions or would like to explore any of these concepts a bit further. And yes, Anita, I'll hand over to you. You're on mute, Anita.
Thank you. That old chestnut.
Yeah.
Look, thanks. That was a really informative presentation, particularly addressing some of the challenges that early stage startups have in regards to IP and commercialization and trying to seek that early stage investment. I'll start with some of the questions that we've had through the registration for the webinar. On that theme of what are early stage investors really looking for, particularly in regards to freedom to operate. So You want to show, you said in your slides that, you want to show that you've got sort of done the IP hygiene factors. So we're assuming that you own the IP, and that the IP initially covers those commercial embodiments. But I think in regards to the freedom to operate piece, how extensive should that search be in the early stage? In terms of, we're talking like, state of the art, we're talking about like, international, due diligence reports, like where on that continuum could I start as a startup?
Yeah, so as I sort of explained previously, the thing with investors is they know the complications around doing things like full-blown freedom to operate. They also know that generally speaking, if they're coming in at an early stage, the technology is still a long way off hitting the market. I mean, the way to look at freedom to operate, and if we're talking sort of really full-blown freedom to operate, is it's only at the patent attorney end, it's only really a viable thing to do properly if you actually know exactly what it is you're doing. Because oftentimes the call on whether a patent is an infringement risk or not is going to be in the detail of, am I going to be doing this specific thing? And you might not know early days whether your final commercial product is going to be doing that. So you actually don't know what your commercial embodiment is early days. So what is really more important at the early stage is more having an idea of the landscape. So it's not full blown uncover every patent I can and actually analyze it for infringement, because you're probably not going to be able to meaningfully do it without having a thing as your comparator, which is your commercial product. But having an idea of who the players are in the market, what their patents are covering, both from the perspective of trying to foreshadow a bit of freedom to operate type stuff, but also understanding, even from an R&D perspective, I'm working in this area. J&J are filing a lot of patents that are specifically around the sensing bit of this. Maybe that's where things are going, and either that might tell a story of maybe I need to focus there, or it could be that I might want to focus at a different end of it. But yeah, it's that landscape knowledge of what's generally out there, what a competitor's doing. That's probably all you need at early stage.
Could I use it? I was going to say, sorry. Could I use an AI agent for that? Like, let's keep on topic with all it. So,
yeah.
Is that a thing? Like, and you could do a due diligence report that would satisfy early stage seed investors?
Early stages is you can obviously run your own searching. There's a lot of free patent searching databases out there that one can use. So you can do a lot of preliminary searching to try to get a feel as to what's out there. I'd sort of recommend like something like eSpaceNet, if people have heard of that or not, Google eSpaceNet. But generally you might use a combination of like keywords and patent classification codes, and you might try to effectively build up your own search string, which you can do sort of yourself. Now, obviously, getting a professional to do it is obviously going to be safer, but early stages, funding's low. Being able to do some searching and getting a flavor for what's out there is important. Because it's also important for any early stage patenting as well, because when you come to me and go, I've got this thing and I want you to draft a patent application for it, it's a lot easier for me, and I'll do a far better job if I'm not drafting in the dark. If I know, hey, these are what competitors are doing, and you're able to then tell me this is what they're doing, here's where I'm doing something different, and sort of focus me on here's the key bit. That's going to allow me to do a better job, and also allow me to try to draft the application in a robust manner, so that if the stuff that you're aware of as being close does pop up during examination down the track, I've hopefully put in enough sort of things in the document to allow us to sort of get around it. Now that's sort of starting to get into some patent technicalities there, but yes, I think doing some preliminary searching, if you can, is useful. There is a school of thought around doing that searching in a manner, and this is the ultra conservative side of things, is try not to do your searching in a manner that actually says what your invention is. And particularly if you're using a lot of AI, especially the sort of the free public AI, the inherent risk of sorts, albeit it's one of those things where you never, I haven't seen it in practice be the bring someone unstuck. But if you were to put in your invention into AI, in theory, where's that information going? What's going on with it? And is it going to potentially pop up down the track on someone else's screen, and potentially be something that ends up jeopardizing your ability to validly protect later? I guess so the caution there is, if you can do your searching without really giving away what you're doing. And I think in a landscape setting, you probably can, if you just sort of put in a few keywords around the area and maybe some specifics around it and find things that are close. That might give you that initial outcome that you're after.
Yeah.
And then for the investor side of things, I can't say I've seen reports that AI spits out for these things done before. But I think if you can go to the investor, even if it's like in a PowerPoint presentation, and go, we've done some searching, we're aware of these competitors that are in this close space, they're filing patents around this area, that's probably going to potentially tick that box to show them that you're IP aware of the landscape.
Sure. And we'll mention some of those search options after this webinar, so that we can send that through to participants. And obviously with the caveat of, make sure that you're behind firewalls when you're doing those searches, rather than just putting it straight through to ChatGPT or something like that. I've got a couple of other questions with regards to, you talk about like the ongoing self-assessment, and, you've already said, you can pivot. So your initial commercial embodiment may not be quite the final one that you want to get the patent granted for. How do you then go about sort of enhancing, changing, refining something where that commercial embodiment becomes clearer?
Yeah. So typically, if I'd run through like a typical life cycle, you might have your prototype, it works, you file your initial patent application. Generally speaking, how it works is you might file a provisional application that sort of sets in your priority date, if you will, so the date you've sort of invented your invention for all intents and purposes. You then get 12 months before you have to file what is called a complete application. And normally what happens is we tell clients that in that 12 months, you're probably doing some more development. Obviously, keep that under wraps, and then come the completion deadline, we can effectively supplement the content from the supplement that new content into the overall final application that we file. But once you file that complete application, that's effectively content lockdown. So anything you then develop post that 12-month period becomes effectively stuff that you're going to have to make a call on as to whether it warrants further patent application filing. So effectively layering further patent applications to cover these further developments. And sometimes if the pivot is such that it renders the initial filing obsolete, which can happen. I mean, in an ideal world, hopefully the first one is drafted broadly enough and the concept is at least broadly enough defined so that the refinements just become add-ons effectively rather than complete pivots. But there might be a time where the pivot is such where you end up going, well, do I continue the patenting process on that first filing if I've now gone in a completely different direction? Or do I effectively pull the pin on that one and start focusing on this refined filing, which is a lot closer to where I'm going to end up anyway? And that's a call that you sort of ideally are sort of in making with your patent attorney, because there might be reasons why keeping the first stuff around is useful. But it could end up being a nice spot to save some money in ditching that initial filing if it's no longer of any value, and sort of focusing in on the later filings. But I guess the more conventional route is you have your initial prototype patent, if you will, that sort of hopefully covers sort of the foundational concept. And then as you start to sort of build it up and add in, as you start to get to stuff like manufacturability, usability, you start to add in a lot more features. And then in those circumstances, it becomes a question of, one, do I need to file new patents for that stuff? Is it worthy? And then two, as the claims of your first application start to go through examination and you're starting to work out, well, because normally we draft these patents to be quite broad, at least the patent claims to be quite broad at first instance. So, generally we sort of say that if our first drafted broad claim goes all the way through, we've probably done something wrong, in the sense of we've left probably some potential scope on the table. So generally speaking, our broad claims are generally going to there's probably going to be some prior art, some stuff out there that is going to render us not being particularly novel or inventive. And then we have to start constraining the claims to get a bit more specific. And then the importance then becomes whatever we are doing to constrain our claims needs to still read on to where we are with our technology development. And if we start making amendments that don't marry to what we're doing, then you get to that point where you're not covering what you're doing.
Mm-hmm. Is there a way of understanding the likelihood that my patent will be granted, and I'm thinking that with conversations with investors, and especially as you're going further down the track, and particularly in relation to, we had a pre-submitted question, which was around patent examiners, is it getting more difficult to get a patent granted in terms of level of inventiveness and novelty? Is that tightening up now? Are you seeing a trend in that direction? So I can't hand on heart say to investors, likelihood of my patent being granted is now becoming a little more difficult. Is that happening, or is that just a
No,
bit
look,
of a...
look, as a generic trend, I definitely don't think that that's the case. I mean, the novelty and
Okay.
inventive step laws, I mean, you don't need to be more inventive today than you needed to be, 2 years ago. So no, I wouldn't say that's a trend. But in terms of that prediction of where it's going to end up piece, it sort of depends on exactly where you sort of are in the process. Now, obviously, one absolute early stage thing you can do is that patent searching I was talking about, and that sort of falls into that landscaping piece to some extent, although I'd probably say landscaping is more of a subset of an overall sort of patentability search. But basically, if you find some prior art and then you go, okay, I can see where my key distinguisher is, and I can't find that in anything, then you can probably, at least at early stage, hand on heart go, I think this is where my coverage is probably going to wind up. And depending on if you have filed a patent application, you can get patent searches done on the patent applications. And depending on exactly where you're on the process, you've potentially, by the time you've spoken to investors, had some level of patent search done, probably by the Australian Patent Office, which provides you a sort of early indicator of where you sit from a patentability perspective. Now, oftentimes those reports will probably be negative at first instance because that's just the way examiners tend to roll. They tend to sort of play off anything as being potentially obvious until you formally rebut it. But in the early stages of the patent process, you're generally not in the midst of full-blown examination, the tit for tat yet. You're just at the early sort of discovery stages, I guess, around it. So examiners will issue examination reports with what they found to be the closest prior art, their sort of opinions on where you sit relative to that. And then you can sort of provide these to investors potentially and go, well, this is the search report we got. The examiner indicated that our broadest claim wasn't patentable because it's quite broad, but they did indicate that some of these other features might potentially be patentable, or it might even be the examiners poo-pooed the whole thing, but we disagree. If our patent attorney thinks that we've got good prospects of getting around this because they think they can argue that these features are in fact patentable. So that's sort of what it might look like at the sort of the earlier stages when you haven't got claims granted and therefore set in stone yet.
Okay. So changing track a little bit, thinking now about sort of geographical coverage, jurisdictional coverage.
Yeah.
You mentioned the US as sort of a bit of a no-brainer. We should be considering that as a market. But if you've got a limited budget, so again, coming out of a university or an early stage startup, what other countries do you think, for medical devices where there's, generally a pretty good market, where would you advise to then consider next after the US?
Yeah, I mean, I guess oftentimes when you're thinking of coverage, or as in country selection, you're thinking probably first with a lens of where's my potential sale jurisdictions or my main sale jurisdictions. So the US obviously is generally number one for a lot of parties. Then you're probably looking at things like Europe. So the European process is a centralized process. So you can file a European application, go through the centralized process, get it granted, hopefully. And then effectively, without getting into the complications of the European process, you can select what parts of Europe you want coverage for, and the more of Europe you want covered, the more expensive it is, as sort of a general rule, I guess. And then so you go from your sales jurisdictions through to, okay, if I've got my main sales jurisdictions, and other ones might be really tech based. I mean, there might be certain tech which, let's say your main competitors are Japanese, for example, where you might go towards getting some protection in Japan, for example. There might also be manufacturing considerations. Where are my competitors manufacturing? If they're manufacturing in China, then one way to potentially cut them off is by also filing in China. That sort of is again part of the mindset. And yes, you're generally going to have limited budgets. The country selection step is probably the big cost explosion step of the process. If you sort of try to map out your patent costs over time, the biggest sort of cost event or singular cost event is the country selection step. And so there is an element of going, well, what's my budget? Where am I? What is my plan? What is my business plan ultimately? And how do I try to best map that on? If you can afford more countries, maybe you do that, but it's not always as simple as just saying, well, if I can get 10 countries, let's go 10 countries, because again, that might not be money well spent if, for example, most of your sales are going to come out of 2 or 3 main jurisdictions, and maybe money is best spent elsewhere to pick 3 or 4 main. So, I mean, as a ballpark, I'd probably say 3 to 6 countries is what would be, I'd say, probably typical in medtech. Generally, like in pharma and some biotech, they go heavier because the dollars at stake are a lot more, and they might go 10 plus countries. But typically in medtech, average is probably more like 3 to 6. And I won't rattle off countries just for the sake of it, because there are generally reasons for them. But generally, you might go home base. If you're Australian, you probably will file in Australia invariably, even if it's not sort of the absolute main market. You file in the US, you file in Europe, and then really you expand out from there depending on budget and other considerations.
And that's more linked to commercial market access strategy, really, and sales strategy. Are there any, I suppose, red flag countries where you're going, oh my gosh, this takes an inordinate amount of time and it's really, really expensive? Like, is there things we should be considering if you're going expanding from, the 4 domains that you listed?
Well, funnily enough, a lot of the times the more obtuse jurisdictions are the ones that end up being more expensive, which so you naturally probably avoid those. Look, I mean, part of the big element for national filing costs is translation fees. So normally, if a country requires a translation of the patent application into their language, they're going to be the more expensive jurisdictions generally than the ones where you can file the like an English version of the application. So but in terms of other sort of red flags, I guess, look, some jurisdictions, so classic case, so methods of medical treatment, let's say that's where your real invention is. Europe doesn't allow you to protect methods of medical treatment. Exactly. I mean, there are potentially ways that those sorts of inventions can be framed by where you can get protection in Europe. But generally speaking, if the only way if you're able to define this thing was in a form that was going to read as a method of medical treatment, then you might go, well, there's no point filing in Europe because there's no chance there. So that's money saved right away. So there are those sorts of considerations that sort of come into it. It might also be somewhat, there's nothing that says you have to do the same thing with every one of your patent filings. So if you have your sort of broad foundational tech, you might potentially go, harder on that one than you might on some of the narrower versions later down the track. Or in some cases, again, depending on circumstances, you might go the other way because you might go lighter on the broad concept, get coverage for those, and then the commercial versions that are the more narrow ones are the ones where maybe you do go a bit harder on. So, yeah, the it depends answer is probably always going to be true for a lot of these things. But yeah, I think a lot of these are, if you discuss these with your patent attorney, let them in on the business side, because often we're best placed to advise when we actually know what you're trying to do, rather than sort of just being the bit at the end where you just tell us what to do.
Yeah, or scattergun,
Yeah, I mean, so the more we know what you guys are trying to achieve, the better. And equally, sort of talking to the patent claim side that I was talking in the presentation, the more you probably know what we're trying to do, and the more engaged you are with what we're trying to do, the better job we'll do as well. Because the worst situations for me are the ones where I'll send a client a draft, and then I just get a one-liner email that says, "Looks good, please file," and you're like, "Did you read this thing? Like, I'm good, but I'm not that good."
Yeah. No,
So yeah.
Yeah, for sure. Someone's just asked about whether a patent needs to be fully granted or whether you can go to investors with just a provisional patents. And I think we've answered that in terms of yes, you can be at that earlier stage.
Yeah.
And especially, and we've talked about like sort of early stage, patent filing, like the patent examiner sort of notes and things like that, like in terms of that initial freedom to operate searches, things like that. So I think that's all been covered. Is there a final takeaway, Robbie, that you think actually, and part of that, apart from the, don't, set and forget, but is there anything else that you would like to impart?
Uh, I think just the concept of being IP aware and being able to make conscious decisions about what you're doing. So patents aren't the panacea, and depending on the technology, patents may very well not be the avenue to go down. But being able to make active calls, so capturing the IP early, and then being able to assess and go, how is protecting this, and how's that all tying back to my business plan? That's the most important part, because patents per se, or having a laundry list of patents, isn't in itself the thing that drives value. They have to be commercially useful. There has to have been thought process put around it. And I think, yeah, I think making conscious IP decisions rather than letting them sort of happen by accident is probably one of the key takeaways.
Great. Well, I think that's a good place to end on. So, look, thank you once again, Robbie, for your sharing your expertise today and being so generous with your time. And thank you, everyone, for who joined the webinar. We hope you found the session really valuable and has given you some key things to consider when developing your IP and investment strategies in parallel. So when you log out of the session, there'll be a short survey that'll pop up when you leave the webinar. We really appreciate your feedback, and if you could just take a couple of minutes just to give us some feedback, that would be fantastic. We do take your feedback on board, and it helps us shape future webinars. I'd also like for you to keep an eye out for our next webinar, which is US Medtech Market Entry and Lessons on the Field. And this will be delivered by Chris Carter, who is very experienced in the US market. So those of you that are considering the US market as a sort of a first market entry, keep an eye out for that. That'll be on June the 11th. Enjoy the rest of your afternoon, and I will look forward to seeing you at the next session. Thanks very much.